SJC-10228.
Good morning, Your Honors. May it please the Court. Leslie O'Brien for Joshua Whitaker. May it please the Court. As the Court knows, Joshua Whitaker was convicted of first-degree murder under two theories, deliberate premeditation and extreme atrocity and cruelty. At trial, it was not disputed that the defendant killed the victim, and defense counsel did not attempt to argue that the defendant should not be convicted of murder. His argument was that the testimony and the evidence was insufficient to find Joshua Whitaker guilty of first-degree murder under either theory. On appeal, the defendant has raised the same issues, stating that the evidence was legally insufficient on either theory. In regard to the matter of to the theory of premeditation, the only evidence offered to support that theory was that the defendant had contrived to be alone with the victim, Ms. Owens. There was testimony from her friend that the defendant had convinced the friend to leave them alone. And I'd suggest that that alone, certainly in combination with the fact that there was no evidence of any prior hostility, that alone, his wanting to be in Ms. Owens' company, was not sufficient to establish that this was a premeditated murder.
But I mean, the events that happened, as the Commonwealth refers to it, as the drag path and the various implements that were used, doesn't that suggest that there is a not insignificant period of time that this occurred in that supports the idea that there's premeditation as well?
I'm certainly aware of the cases that indicate that where there is more than one blow, where there's an effort to kill that occurs over time, that can support a finding of premeditation. But I would point out that in those cases, in the cases that are cited, I believe in both briefs, involve circumstances where and I'm looking for the citations without success, but the cases involve a situation where an unfortunate victim did not die immediately, and so that there were additional efforts, concerted efforts over a period of time to kill the victim who was still alive. The cases were Commonwealth v. Degro and Commonwealth v. Phillips are both cases of that type, and I believe also Commonwealth v. Nolan are cases where it appears that there was either a struggle that went on for a period of time, but in any case, the victim did not die immediately, so there was this concerted, continuing effort to kill. In this case, part of my argument involves the evidence that shows that the victim's death would have been immediate, and that has bearing on both theories of first-degree murder.
Why? I mean, part of that is that you assume that the blow to the skull was the first blow. Why do you assume that, or why do you say that that's the most powerful inference?
Well, for a couple of reasons, Your Honor, and I would point out that that's not simply the defendant's theory. In the Commonwealth's opening statement, the Commonwealth pointed out that the first weapon found at the scene was the hammer, and the hammer was found near the corner of the barn where, according to the Commonwealth's theory, as laid out in the opening statement, these events began. So it's that in combination with the medical examiner's testimony that all of the blows to the head were fatal, and that at least one of these fatal blows was with that hammer that was used, according to the Commonwealth's theory and according to the physical evidence, at the very beginning of the attack.
There was also a bloody log, wasn't there?
There was. Farther along, there was a drag path, And there were, farther along the drag path, there appears that there were implements that were used post-mortem. And that certainly is another part of the argument that I'm making, that it does appear that there were injuries, many injuries, unfortunately, that were inflicted post-mortem. And the defendant's position is that those injuries are not to be considered on the issue of extreme atrocity and cruelty. And I base that on the model instruction, which is based in part on Commonwealth v. Gould. The model instruction states, and I'm going to read this in part, it's brief just for the sake of accuracy, that the inquiry regarding the theory, meaning extreme atrocity or cruelty, focuses on two things, and those are, quote, the defendant's actions in terms of the manner and means of inflicting death and on the resulting effect on the victim. So as far as the defendant's actions, it's the action that actually causes death.
But doesn't the medical examiner suggest that not all of the wounds were inflicted post-mortem, so that there was at least one, and probably more than one, that was inflicted pre-mortem, pre-death?
I did look at that testimony, and it's quite vague. The medical examiner does use the word in describing the bruises and abrasions. The medical examiner at one point uses the term, some of these were inflicted post-mortem. But when he goes on to describe those injuries, he's describing post-mortem injuries and explaining why these injuries are considered post-mortem injuries.
I'm sorry, go ahead.
He doesn't describe any of these, the scrapes or bruises, as being inflicted other than post-mortem.
Okay. Now, even if the hammer were the first used, the first
Yes.
implement used, is there any indication that the first blow struck with the hammer penetrated the skull?
There's the description of the injury, I'd submit, is consistent with that, and the medical examiner's testimony.
But there were some fractures, weren't there?
There were fractures, yes.
And the evidence could support an inference that a blow was struck with the hammer that resulted in a fracture, and then a second blow was struck with a hammer that resulted in a penetration of the skull.
I'm not sure if that's, I have to say I'm not sure if that's consistent with the testimony. The testimony of the medical examiner was very brief under these circumstances. I'm not sure what the explanation
was there any
for
evidence
that
that
is.
suggested that every blow with the hammer necessarily would have penetrated the skull?
There was nothing that specific. The testimony of the medical examiner was very brief and a little bit vague under the circumstances. It seems it could have been that much more could have been said, but I'd suggest that was certainly the burden of the prosecution if they wanted to bring out more details of that particular injury. Is it your position that an intentional blow to the head with a hammer alone would not have supported a verdict of deliberate premeditation? That is my position, even though I'm aware that there are cases that say that a single blow can be sufficient. Because in looking at those cases where it's been found that a single blow is sufficient, those cases also involve the second Gould consideration, where there is clearly very significant suffering on the part of the victim. And I'm referring to the cases.
But why is that necessary? If you intend to kill somebody and you use such force to do it, if the death is accomplished immediately without any suffering, are you saying that you need suffering for deliberate premeditation?
Not for deliberate premeditation, but for extreme atrocity or cruelty.
But what about for extreme atrocity? What about for deliberate premeditation? An intentional single blow to the head with a hammer, with substantial force cannot be a basis for a deliberate premeditation verdict?
I would say that it could not be under the circumstances of this case, Your Honor, because the only thing that separates first-degree premeditated murder from, if I could go back just a little bit, premeditated murder, of course, requires an intent to kill. So that certainly striking someone in that manner fulfills the element of malice. What separates that from premeditated murder is some evidence of reflection, and in many cases, we're told...
He selected a hammer to hit somebody in the head. I mean, if he had selected a gun and shot him in the head, you're saying, or you wouldn't claim that wouldn't support deliberate premeditation, would you, with one bullet?
Well, it depends on things such as there's a recent case where there was I believe it's it's not recent, okay. There's an older case, a 1977 case, where there was a strangling that occurred with a cord that the defendant found nearby.
But wasn't it right there?
There was evidence that it was nearby. And in this case, it does appear that any of these implements that were used, even though there wasn't direct evidence about where they may have been, I know the court has access to the photographs. You can see that there's some disorderliness about this scene. There's a hammer near a garage. There's some logic to a hammer being near a garage. There certainly isn't any evidence that the defendant retrieved a hammer and then came back and attacked the victim in this case.
But you've got, moving beyond the single bullet, you've got a hammer, you've got various other implements.
Yes.
So when you look at all of those, can't you infer that there was an intent, that there was premeditation? When you sort of look at there's the first blow, but then there's also the series.
Yes, there is a series of blows that occurs, and my argument regarding that is that we don't know what was in the defendant's mind when he inflicted those other injuries, but it appears that the victim at that point must have been dead. There was no evidence at all of a struggle after what happened near the barn. There was dragging. There was no evidence of defensive injuries, is what I want to say. Everything seems to indicate that death came immediately.
But is there any evidence that the defendant knew that?
I can only say that it appears that he must have known because of the nature of the injury and because the...
So therefore, if he must have known, why isn't that deliberate premeditation?
I'm saying that he must have known that she was already dead.
He must have known that the first blow killed her, you think?
I think
is that what you're saying? I'm not trying to put words into your mouth.
I do. I think that the evidence was that the blow that was severe enough and must have brought the victim down immediately, and it must have been clear that she would be dead.
Now let's assume all that you say is true, that the first blow killed her,
yes.
That he acted without thinking. What do you do about Commonwealth versus Barboza, Commonwealth versus Boateng, Commonwealth versus Eugene, all of which say that blows need not be inflicted before death to be considered in the calculation of extreme atrocity or cruelty?
I believe that, I know that you mentioned Boateng, and I believe that is an exception. That's the case with the attack on the young child, where there possibly was only evidence of one blow and possibly no evidence of suffering, and that does appear to be an aberration. I need to ask you to remind me of the other cases that you mentioned.
Well, Barboza, let me read to you from Barboza. The fact that Surrette's heart stopped beating before the blows were inflicted does not negate the relevance of these blows in determining whether the murder was committed with extreme atrocity or cruelty, because the defendant may not have known that Surrette was dead when he repeatedly struck him. And then that cites Boateng, evidence of that defendant strangled and kicked baby boy after throwing him to floor, relevant to the theory of extreme atrocity or cruelty, even if hitting floor alone caused death. And then Commonwealth versus Eugene, multiple stab wounds, including some inflicted after the victim was already dead, gave jury ample basis on which to conclude the killing was committed with extreme atrocity or cruelty. So
But yes, I do understand your point. In Eugene, this was a matter of a total of 19 stab wounds where 2 were found to be inflicted post-mortem. So it's a very different type of situation. Certainly the 17 stab wounds pre-mortem would be sufficient to meet the Commonwealth's burden. And actually, the statement, I am suggesting that the statement of the law that post-mortem injuries can be considered, assuming for the sake of argument that the defendant knows that the victim is dead, there possibly is some importance to that. But it conflicts with the model instruction that tells the jurors that the focus is the actions that cause death. So to say that actions post-mortem may also be considered, I'd suggest that contradicts the model instruction in Commonwealth v. Gould on which it's based.
So does it matter then as to whether or not the defendant knew the victim was dead? I mean, are you saying that it's one thing for someone to repeatedly stab or strike somebody and may not know that the person is dead, even though the medical examiner may say it was the first blow that did it, versus go to the Iliad, Achilles taking Ajax's body and pulling him along the ground on a chariot for an hour, clearly knowing he's dead and inflicting injury on the dead body. Are you saying that that's the distinction?
Whether the distinction is the knowledge of the defendant, I think is the question. Yes, I believe if there were evidence of that the defendant did not know that the victim was dead, and again, I would suggest that she would clearly have been dead at that point.
So it would really be the same for both deliberate premeditation and extreme atrocity or cruelty, I think is what you're saying. That if the defendant knows, then knows when the victim died, then post-mortem injuries that he or she inflicts are not relevant to either theory. Is that?
Yes.
That seems to be what you're saying.
I'm having a little bit of trouble with the question, but I think that's correct. That if there were evidence that a defendant thought that someone was still alive and was continuing to make the effort to assure that the person was dead, that would be a different circumstance. Yes.
I'm going back just quickly because I'm still thinking about, I thought you said that the depression was in the barn. It wasn't in the barn, right? It was outside.
The beginning of the attack was outside.
Right, okay. And do we know from the evidence how far outside the depression was, for example?
It doesn't
beyond
look
the picnic
far.
table?
There were a number of pictures that were introduced, and it doesn't look far. From what you can tell from the pictures, it does not look far outside the barn. It looks as if everything begins to happen right near the corner of a barn where there's a barrel overturned with blood and a purse dropped to the ground.
And but your theory on premeditation also depends on the fact that there's a hammer nearby.
Yes.
And so notwithstanding the fact that there's a depression and the hammer found further on, and there's nothing to indicate where the source of the hammer was.
There's no proof of the source of the hammer, and okay. I'm saying that it would have been certainly helpful to the Commonwealth's case if they could have shown that the defendant went to get the hammer. But there's no proof of that, and it's a circumstance as shown in the picture where there are tools and different items all about the scene. If I may have a chance to make one final point regarding, I'd suggest that the Commonwealth's theory of what I believe was the Commonwealth's theory of the case, that the hammer was used first in combination with my theory, that there was no suffering. The photographs do appear to indicate, the photographs are clearly difficult to look at, but do appear to indicate that there are no injuries to the front of the head. The injury, the large injury, the terrible injury that was inflicted appears to be to the rear of the head. So there's certainly evidence from which it could be derived that the victim did not see the attack coming, did not know she was being attacked.
Thank you, counsel.
Thank you, Your Honors.
You please the court. Catherine McMahon, Assistant District Attorney for the Commonwealth. I have allergies, so my voice is kind of raspy, and I apologize for that. Apart from photographs of the crime scene, the jury also saw a crime scene videotape. Trooper Fitzgerald, it's his testimony in volumes 2 and 3 of the transcript where he describes the drag path and the objects found along the drag path. We assume that the end of the drag path is where the victim's body is found, and the beginning is in the area where the ball-peen hammer was found. He testified that the depression in the ground that was like 4 to 6 inches wide and had blood in it was near the area of the hammer, but a few feet from the hammer. So circumstantially, that depression could have been caused by the victim's head being on the ground while blows were being administered to it. I agree that the medical examiner testified that all of the blows were fatal blows. He couldn't say which one was fatal, but the medical examiner never said that death would be immediate based on any of those blows. So there's no evidence that the victim was conscious throughout this, but there's no evidence that she was immediately dead based on a blow to the skull. The medical examiner described...
The medical examiner was silent as to whether or not...
He wasn't questioned about whether death would have been immediate based on one of the blows. He was asked whether, which one, could he tell which one was fatal, and he said, no, all of them are fatal blows, plural.
Okay, so if the burden then is yours to indicate that there was conscious suffering, it sounds as if you haven't met that burden.
That's not my burden. Under either extreme atrocity or cruelty or deliberate premeditation, suffering by the victim is not an essential element.
It's not an essential element, but to the extent that you would be, certainly if you had it, you'd be arguing it.
If we had it, but there's, going to deliberate premeditation first and then extreme atrocity or cruelty, this is unfortunately a textbook case for both of those. You have multiple blows of the victim. The medical examiner described the skull fractures as extreme and severe. He said there were at least 5 or 6. The EMT who had responded to the scene and was one of the first people who tried to administer aid to the victim, she said there was a hole in the skull and she could see the victim's brain.
Are the blows to the back, as counsel suggested, are they to the back?
I believe so.
Suggesting that the victim was turned away? No blows to the front, all to the back?
No, the marks to the victim's face and the front of her body were abrasions to the face, the chest, and the abdomen, which the medical examiner described the face, chest, and the abdomen as being post-mortem because it wasn't blood but a different fluid. But there were also like scratch marks and other marks and bruises on her arms and hands apart from the marks that he said were post-mortem. So she was, the evidence suggested she was dragged face down and that there were implements found at different points that have reddish-brown substance that tested presumptively positive for the presence of blood, and which when DNA analysis was determined to be the victim where she was, and then the defendant's palm print in her blood is found on the hedge clippers. So she was hit with the hammer with at least one of the 2 weights, although both of them appeared to have blood on them, and they're found in different places from the hammer. And she's also struck by a log, and the medical examiner said some of the blows from the ball-peen hammer, or from a hammer, but others from a pipe or another object. And then the hedge clippers, she was hit, it was a sustained attack in that her body was moved from place to place while she was face down and being dragged, and blows were administered to her at different points along the drag path. So not knowing that there's no evidence that she was conscious throughout this, but the blows were severe and vicious. If more than one was administered with the hammer, she was struck in the spot where the hammer was, then he moved on after more than one blow with the hammer to administer more blows to her at further points upon the drag path. In terms of deliberate premeditation, the number of blows, the number of weapons, the fact that she was moved from place to place during this sustained beating all suggest that there was a specific intent to cause death and that it was a product of reflection, if not a prolonged product of reflection. As to extreme or cross-rear cruelty, the number of blows...
Let me just back up for a minute. If we were to conclude that the record indicates that death was caused instantaneously after the first blow, and just assume that, why would a single blow to the head with a hammer be deliberate premeditation?
If it's a single one, I dispute that you could say that from the evidence that it was immediately fatal.
It would just humor me.
Okay, I'll humor it. But it's a blow with a hammer to the skull from attacking the person from behind. That would be administering it to a very delicate or sensitive, like crushing somebody's skull, because that's what it was. It was fractured. The place where the blow was placed, it had to be at close range because it would only be something in somebody's hand, arm length. So being behind somebody and attacking them and hitting them in the vulnerable part of their body, the head, it's not like shooting somebody in a thigh and them bleeding out, where you might say, well, although it's a dangerous weapon and it's at close range, you would say deliberate premeditation. But that kind of assault on a vulnerable person of a person's body is a killing blow. And you can infer the intent to kill from the mechanism that's used and where the mechanism is employed on the victim's body, the back of her head when she's defenseless to it.
But you need more than just a killing blow for the deliberate premeditation.
But
that gets you to murder, but it doesn't get you to...
But picking up the hammer and swinging it at the person's head while their back is to you or where they're turned away so that you hit the skull, it shows planning to me. And you have more than one blow with that hammer. So we can't tell whether she died instantaneously from the first blow. I don't think the defendant could tell that, but there were at least 2 blows with the hammer, possibly more, and then the other objects. So his intent to kill and it's premeditated because he acted through a long process with a number of weapons. And in a number of cases, this court has said multiple blows and with different objects, even when the objects are all sort of in like the same area, not moved like this along a path, is sufficient to show deliberate premeditation. The court only has to sustain this on one of the 2 theories of first-degree murder. If the court somehow finds that her death was immediate and therefore the first blow, you ignore every other blow that he administered, that deliberate premeditation isn't sustained, then this is overwhelming evidence of extreme atrocity or cruelty. The victim suffering, as I said, is not an essential element. Death under extreme atrocity or cruelty can be administered through the first blow. As Your Honor cited cases that I had cited in my brief, Boateng and Eugene, the fact that some of the blows were administered after death doesn't remove it from extreme atrocity or cruelty, but this was overkill. The number of implements, the number of blows, the severity of the blows. She died not just from the skull fractures, but the medical examiners said she died from multiple blunt force trauma to the head and the neck. So there were neck injuries as well as head injuries that he opined were fatal, because that's what he said was the cause of death.
Just a factual question. You talked about the scratches on the I think forehead, chest, and abdomen, and then you said there was bruising on the arms.
Bruising and lacerations on the arms and the hands, the medical examiner said.
Did the medical examiner or anybody say that those ones were defensive wounds?
No, there's, no, I'm not.
No, you're not suggesting that.
I'm not suggesting that because
It's also being
dragged while being face down.
Okay.
Was there any testimony about, or any evidence of, on the question of whether or not the victim continued to bleed along the length of the trail, or how much blood was determined to be in her body at the time of autopsy?
There was no testimony about the amount of blood that was in her body. There was blood along the trail, but there was no testimony as to like the amount of it or the significance of it. The jury saw photographs of her body, which do show that there is blood on her, but I can't say that that's from anything other than a hit to the head, which would have caused the blood to come out. But the medical examiner was specific that the abrasions on the forehead, chest, and abdomen, which you can infer were caused by her being dragged, were post-mortem because blood wasn't present on those, but there were cuts and bruises on the hands, which from the photographs you could see there is blood there. He didn't specify that those were pre-mortem or peri-mortem. He only specified that certain wounds were post-mortem.
Was there blood along the entire length of this path, or only in the spots where the implements were found?
There was blood in that depression, and there were blood on the implements. I would have to go back and look at the record to tell you whether Trooper Fitzgerald said, there were streaks of blood. I don't think so. He was calling it a drag path.
About how long was that path?
He described the crime scene as 20 to 30 yards in total, but I think he was talking about the whole back area of the defendant's family's property. The defendant has a sketch at page, I think, 58 of his appendix, which show things, but I don't think it's to scale. And perhaps if the court wanted the exhibit of the crime scene video, which would show the property, and that proceeds along the drag path, you'd be able to see what the jury saw in terms of distances and objects. And my sister is correct that the property was somewhat messy. There were implements all over there. I do note that weights like the two weights that were probably used on the victim's body, there were some of those on a picnic table by the barn. So it's not necessarily that he was fortuitously came across things as that he found them along the property. But
what does the record suggest as to where these implements might have been located along the drag path before they were used? In other words, were these two 10-pound weights, were these like barbells?
There were barbell weights. There were other weights that were found on a picnic table by the barn.
Where were the barbells kept, do you know?
Don't know where the barbells were kept. Know that there were weights like those weights on the picnic table. And these two weights here were found in different places along the drag path. I think one was found like in a wooded area, and one was found more in the lawn area.
Is there anything in the evidence to indicate that 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 the implements were used as they were discovered by him or observed by him on the drag path, or whether he went to get them and was he carrying them, all of these implements at the same time, or
I don't think that would be a reasonable inference that he was carrying them all at the same time while he was also dragging.
And there's no indication that he went to get one each time? He had to go retrieve it from some space?
The only possibility would be with other weights being on the picnic table, that perhaps he went to the picnic table to get the two weights that he used. But other than that, it may well be that he just stopped and picked up objects that he found on the path and then administered more blows to her with the objects as he found them on the path, like the log.
But we don't know.
But we don't know. He only admitted in the ambulance that he was a murderer, but we don't know what the exchange was between the defendant and the victim that precipitated this. All we have is the physical evidence, and his admission that he was a murderer in order to, we don't know, there's no why or what triggered this, but it's a sustained attack with multiple weapons over several feet, which horrific injuries to the victim, which caused her death. Whether the first blow was fatal, whether it was immediately fatal, there's no testimony on the immediacy of that. But this is definite extreme atrocity or cruelty, and I submit definitely deliberate premeditation. Not just sufficient under Lattimore, but I submit that the evidence is overwhelming in this case. Going to the defendant's second argument about the evidence being that you should reduce it to, because it's more of a second-degree case than a first. This is clearly a first-degree case. The defendant does cite to his background, which is a troubled background. That was not presented to the jury. That does not prevent this court from considering his background. But the report by Dr. Ebert does not suggest this looks like deliberate premeditation. This looks like extreme atrocity or cruelty, overwhelmingly. There is nothing in the defendant's background. Dr. Ebert doesn't say that the defendant could not specifically intend to kill or that his ability to do so was impaired. He doesn't say that his ability to deliberately premeditate was impaired. He does not say that his ability for extreme atrocity or cruelty, you only need malice, and it's the three prongs of malice, that his ability to harbor those two, the two other prongs, was impaired because of his mental condition. The Conanan case that the defendant relies on, there was testimony about the defendant's severe mental illness. I think a lack of responsibility defense was offered to the jury in that case. And in that case, it was clear that the cause of the victim's death, the woman killed her own child, was a result of the woman's severe psychotic depression. Here, the defendant does have a troubled background. He has been diagnosed with post-traumatic stress disorder, but we don't have any link between that and what happened to him and the victim in this case. Commonwealth versus Gray, which is the first case to recognize mental impairment going to malice. In that case, the defendant testified to a stressful confrontation with the victim, and there were two psychiatrists who testified that when he was faced with a stressful situation like that, his first response might be to flee, but then he might act out impulsively in response. Here, there is a suggestion that he might act impulsively. There's nothing going to his ability to hit the elements of first-degree or second-degree murder, and there is no explanation as to what triggered this killing here. Unlike in Gray, the defendant had testified to a confrontation with the victim where he tried to get away. There's nothing here. We just have a 20-year-old man killing his high school friend in a long, sustained incident with several weapons, several blows, inflicting catastrophic injuries. And despite his troubled background, it doesn't explain it and it doesn't excuse it. And the Commonwealth asks that you affirm the verdict of murder in the first degree on both theories.
Thank you, counsel.
Thank you.